Case arises largely out of a request of a finding by the Circuit Court of Duval County for inverse condemnation against the city of Jacksonville. There is a pond on my client's property, the Simons, which is used to store and treat stormwater that runs off of the streets in a subdivision known as Meadows. After a 2-day trial, the trial court ruled that the streets off of which the water ran, directed through catch basins on those streets, through a pipe and an easement, and then into a pond, which is outside of the easement on my client's property, were not city streets, and therefore there was no inverse condemnation. The court also ruled that because they're not city streets, that the pond was not being used by the city of Jacksonville. And then the court ruled that in any event, the city of Jacksonville had an implied easement, or common law easement as it sometimes is known, and a mutual drain, which we'll get into a little bit later, which is a form of an irrevocable easement. Let me begin first of all by dealing with the issue of whether or not these are city streets. We believe it's purely a de novo issue. The court has to review what the plat says, and the plat very clearly states that all of the drives within the Deer Meadows subdivision are dedicated irrevocably and without reservation to the city of Jacksonville. We believe that that gives a title to the city of Jacksonville. The claim that's been made and what the court ruled was, no, the streets are dedicated to the public. They're not dedicated to the city of Jacksonville. We would assert, Your Honors, that it is the city in this case which is the public. That's how the public acts through controlling these city streets. And as I said, the plat is very clear that it was dedicated irrevocably to the city of Jacksonville.
And who, assuming that Jacksonville took title to the streets at that moment, who had the title immediately before that?
To the streets?
To the streets.
It would have been the developer, Florida Land Equity Development Corporation, Your Honor.
They started off with the whole undeveloped parcel. They built the roads.
Yes.
And then my understanding was the plat was recorded when? That was after some of the subdividing went on, right? Or do I have that wrong? I used to think of the plat as being sort of step one, but
yeah, the plat is what does literally the subdivision.
Okay.
Okay. The pond was not built until after the plat was recorded.
Okay.
Okay. So we would contend as a matter of law that the city does own the streets. Whether or not the city owns the streets, they certainly have control over the streets, and they have control over the catch basins that directs the water into the pond on my client's property. I would note that on that plat, it does show an easement approximately 20 inches wide between my client's property and the neighbor next door on lot 15, but it does not show on the plat any pond whatsoever, and is admitted into evidence the survey from the very first purchaser of lot 15, which the Simons ultimately became the owners of, shows the pond extending outside of the plat right then and there, and that was in evidence before the court. The court then ruled, of course, that the city is not using the pond because it doesn't own it. We believe that's wrong. But as we point out in our brief, the city's corporate representative, Mr. George Sands, admitted in deposition that the city was using the pond for storage of stormwater outside of the pond. Furthermore, the city admitted in request for admissions that it did not have an easement outside in the pond, outside what was depicted on the recorded plat, the 20 feet. That should have been the end of that issue. At that point, there should have been a finding by the court that as a matter of law, it's been admitted that the city is using this pond out there. Nevertheless, the court went on to determine that the city had a common law dedication to the use of this pond on my client's property. The law is clear with respect to a common law dedication that the burden would be on the city to establish that by clear and unequivocal evidence. Now again, because the city has admitted it has no easements, and easements can be granted expressly as in a plat or by implication, since they've admitted that they have no easement, we should not even have had to address this issue. But the facts don't support that they had an implied common law dedication regardless. First, you have to determine that there is an intent to dedicate private property for the benefit of the public, and then secondly, that that has been accepted. The court relied for proof of intent to dedicate the pond an application for exemption from permitting from stormwater made by Classic American Homes. Classic American Homes, the developer was Florida Land Equity Development Corporation, not Classic American Homes. And even in the pretrial stipulation, the parties stipulated that Classic American Homes in that exemption application represented itself wrongly as the owner of the property. As the deeds and evidence show, Classic American Homes did not even become the owner of the property until 1986, some 2 years after this exemption application was made to the then Florida Department of Environmental Regulation. In any event, the regulations that govern the now Florida Department of Environmental Protection, there's also regulations that govern what now controls these ponds, the St. Johns River Water Management District, dating way back as cited in our brief, says that the granting of a permit does not grant any property rights. So we do not see how a granting of a permit could grant an easement or be an intent to grant to the public an easement in property. Certainly, if the granting of a permit cannot grant an easement, then an exemption from permitting should not be able to do so either.
I'm just curious, so is it your argument that the city is obligated under the inverse condemnation claim to buy the pond or pay you for your client for the market value of the pond or just maintenance costs?
It's our contention that it's an inverse condemnation and they're obligated to pay us for the pond so that they can then use it.
They can then own the pond and then
Yes.
it's their stormwater facility.
That's right.
Right.
Thank you, Your Honor.
Which,
Yes, sir.
if the, make sure I understand some of the issues here. It seems to me that if it's not the city's street, if the water that is going into the pond is not owned by the city, which is my understanding of the city's argument, then none of this makes any difference. It doesn't really matter who owns the pond. It's because it's not the city's water going into the pond.
If it is not, I don't know that you can call it, I don't know if it matters if you call it the city's water or Mother Nature's water. I think that once the water lands on a city street, the city's responsible for the water, so they would be using the pond.
So if the city doesn't have title, which they have contended, to the street, then that's pretty much the end of the inquiry.
I don't believe so, Your Honor, because even if the city didn't own title, and the plat's very clear that it dedicates it without reservation to them, they would at least have control over those city streets to maintain them. They've acknowledged and admitted in this lawsuit that they do maintain those city streets, and in fact, that they need to have this pond in order to maintain their city streets to control stormwater runoff. So I don't think it's the end of the question if they don't own it. If they have an easement right or other incorporeal right to use those streets, which clearly they have
If
to
they
have
don't
under the
own
law.
it, you kind of see it as a third-party action. If they're acting on behalf of this amorphous entity, the public, your argument is fine, you're operating on behalf of the public and shunting the water into our pond.
Exactly.
So we're suing you rather than the public.
Well, we can't sue an amorphous public, Your Honor, so exactly, I would agree with you on that.
So
And-
they maintain these streets.
Yes,
Are they curb and gutter?
yes,
And so they maintain all the necessary maintenance, control. They put up the signs, speed limit signs.
Your Honor, I've been through the neighborhood a few times, but I don't recall if there's a sign or not.
Right.
I do know that they have paved the streets in there. I've physically been out there when they were paving the entranceway.
Well, I mean, that's not disputed, right? They
No, that's
maintain
not
the
disputed in
streets.
this case whatsoever.
What about the water that comes, I guess, following up on Judge Winokur's question, the issue of who owns the water, who's responsible for the water, it seems like your brief sort of assumes if the water is on the street that it's the city's responsibility. What about the water that drains onto the streets from other properties? I mean, the streets capture not just water that lands in the streets. The way these neighborhoods are developed, and I assume this is no exception, driveways, everything runs down to the street so it can get in the gutter so that it can, so it's really a catch basin not for the streets so much as for the entire development.
It is for the entire development, Your Honor.
So
but
how
I-
does that fit in? I mean, if you were to succeed in this appeal and then proceed to an inverse condemnation, wouldn't someone have to determine what percentage of the water was from the streets themselves?
I don't think so, Your Honor, because I think once it lands on city streets and those streets are what directs it into the pond, it becomes the city's responsibility. I would agree with you that you're going to get waterfall from rain, not just directly onto the streets, but you may get some.
But it's an overall system. I mean, what actually directs it to the pond is the the pipe that comes off the street, right? That's not the city.
Yes, Your Honor. Well, it's not, it's the pipe, it's the catch basin that catches the water and then directs it through
Which
the
is
pipe.
not the city's.
Oh, that is the city's. The city has an easement to that pipe. That is the city's, and the city maintains the pipe.
Okay, the pipe that goes from the street
Yes,
down
yes,
the
sir.
road.
They just don't maintain the area outside the pipe that goes into the pond. And that pond extends as depicted on the survey that was introduced into evidence, some 40 or 50 feet on my client's property outside of that.
Okay, I misunderstood.
Also, we'd say that the city has not accepted the pond. They've refused to do maintenance at any time. That would be an indication that they've never accepted the pond. I would also like to address the issue of the statute of limitations. The court presumes that use of a person's property is with permission. And that presumption is difficult to overcome. Any doubt is to be resolved in favor of the property owner. That's what the state of Florida does. It protects private property owners' rights. By ruling the statute of limitations ran when the first purchaser bought that property, the court would have to find that the property was being used against the permission of the first property owner. And there was no evidence of that introduced at trial whatsoever. So the statute of limitations should not apply. Going briefly to the mutual drain theory, as the case law points out, the initial case, Manning versus Hall, that's really a type of license, a type of irrevocable license. And that type of license requires that you have to participate through great expense, either in the construction or the maintenance. The mutual drain cases deal with draining water away from two properties.
So I'm curious, let me give you an instruction that you'll hear in criminal trials, which is called the Allen charge.
Okay.
If you were to be required to present the argument on behalf of your opponents, what essentially is their argument? A, we don't own the streets. B, if we do own the streets, we have a drainage easement, essentially?
Essentially. Into an area that's not depicted on the plat. So in any event, they haven't contributed to the maintenance. They admitted that of the pond outside the easement. It's not a disputed fact in the case. And so we just don't think that a mutual drain can apply. Turning quickly, I see my time's getting low. We did file just one issue against the association here. We had sued the association to make a determination whether they owned part of the easement that the city owned. And the reason we did that is because the developer did an assignment of all of its rights, including all easements under the plat, to the association subsequent to the time it dedicated the easement for drainage to the city of Jacksonville, and that created confusion on our part. And there were timing issues dealing with that.
But
Frankly,
the only way you would say you're aggrieved by the dismissal of the HOA is for ancillary issues like fees and things like that.
that's exactly right, Your Honor, and this is the reason. The association counterclaimed us, saying we had to restore a pond to some pre-existing condition, and counterclaimed saying we were responsible for the maintenance. And then they said they dismissed their counterclaim as moot. Under the case law, if there's a voluntary dismissal where attorney's fees are allowed by statute, we're the prevailing party on the counterclaim. Now, what that may end up meaning is there's no prevailing party here. I'm not here to argue anything beyond that whatsoever. But I will tell you, the trial court has now entered an order, and this is a subsequent judge, not the one that sat in on the case, that said, no, the original trial court said it was moot. Therefore, you're not a prevailing party on your counterclaim, and they're the prevailing party. And that issue will be coming up before this court shortly. And so what we asked the court to do is to say, look, this is a voluntary dismissal under Rule 1.420 of the Florida Rules of Civil Procedure that was made on the record at the trial. It's a voluntary dismissal. It's not a determination by the court that there's moot. Our contention before the court below is that it's most likely there's no prevailing party, but that's not the issue before you.
And I'm going to give you 2 more minutes.
Thank
so
you,
you
Your
have
Honor.
some more time.
Based upon the arguments made today, we ask that you reverse the court below. You hold that there is a taking by the city of Jacksonville as to the pond out on our property outside the recorded easement, which they do have, that we go to a Phase 2 trial on the value of that, and that you reverse the court's determination that the voluntary dismissal of the counterclaim was moot. Thank you.
Thank you. And so the appellee will have 17 minutes. Thank you, Madam Clerk.
Good morning, Your Honors. Jason Teal with the Office of General Counsel representing the City of Jacksonville. I have with me here today Jeff Close, also with the Office of General Counsel. Mr. Michael Orr is representing the Deer Meadows Homeowners Association, who was a co-defendant in this case. We will be reserving some time for Mr. Orr to represent his client. I believe he wants 3 minutes of the court's time for doing that.
Of your time.
Of my time, thank you. Of our time. The only reason that the city is even before you today is because in 1985, the city of Jacksonville accepted a plat for the Deer Meadows Homeowners Association. And they accepted that plat pursuant to Florida statute, Chapter 177, specifically subsection 081 sub 3, which establishes a the statutory mechanism for how local governments establish plats, and also establishes that no local government can be charged with maintenance for some portion of the property without having voluntarily accepted that. As you heard from counsel for the appellant, the pond wasn't even on the plat when the city accepted it in 1985. And so basically, in response to questions from Judge Winokur and followed up by Judge Windsor, this case all culminates in the determination that the city is using the pond. And there are a lot of issues that were presented in this case, and a lot of these issues are but if. But if the court finds that the city's using it, then. But if the court's finding the city's using it, then there's a mutual drain, there's a common law dedication.
But isn't it the city's obligation? I mean, I know for a fact that stormwater laws and regulations have been in place for quite some time. In 1985, there were different requirements than there are today in Florida and possibly under federal law. But isn't the city on notice, hey, if you're going to accept this plat, you need to be aware that there is stormwater. There's stormwater everywhere. There's runoff everywhere. Who's responsible for that runoff in 1985?
Excellent question. Who's responsible for that is the entity that's permitted it through the state. These are all state obligations to treat stormwater generated by a property. So in 1984, there was an application that was made by the landowner or the developer with the state of Florida that says, we want to build a subdivision, but we're so small that we should be exempt from the permitting requirements. State of Florida says, okay, let's take a look at it. So they look, see what the size is. They also have in there a requirement that that developer establish who is going to be responsible for maintaining the stormwater system. So what the developer in this particular case said is, we are going to be responsible for it, and then they put an asterisk, and they said, unless it's accepted by the city or the underlying property is sold. So the developer presented that to the state agency accepted that. They looked at that, they said that's good enough, that establishes that. So the entity that's responsible for maintaining it today, that's a question really that needs to be presented to the state agency that regulates it. Because if the system is not being maintained properly, they're entitled to pursue an enforcement case against the entity responsible for maintaining it. What the trial court did is the trial court looked at all that and said, you know what, there's no proven legal theory for who is responsible for maintaining it, but we know for the variety of reasons that the appellant, the plaintiffs in the underlying case, are not entitled to the relief that they're seeking. So the court found that there were a bunch of different legal theories that apply, and they all hinge on whether or not the city is using the ponds. And I want to have the court understand, from a platting perspective, the city isn't required to accept a plat. That's a voluntary thing that the city can choose to do. But once the city accepts the plat, then it's responsible for making sure that those roadways, everything that's public spaces that are on the plat, remain open for public use. So that's where our obligations lie, is making sure that those public spaces remain open, including the streets. The developer designed a stormwater system to handle the stormwater runoff from the Deer Meadows subdivision. The city wasn't involved in permitting, city wasn't involved in engineering, city wasn't involved in design, city wasn't involved in construction. The first thing the city knew about it was when it got presented with this plat. So it's not a city project. And the case law that's out there, first of all, there's no case really that's on point that we've been able to find and that the appellants have brought to the court's attention where what they're proposing has been adopted as in actual case law. But the case law that's out there is cases where it is a government project that is designed and has the practical effect of directing stormwater onto private property, effectuating a taking, initiating inverse condemnation. That's not the situation that you have here. What you have here is you have a plat that got accepted so that there can be a guarantor that those public spaces remain open for public use. So that is really the only role that the city plays here.
Yes, let me ask a question. Because the city does maintain the roads, right? And I
We do.
guess the drainage system as well, up to the pond, but the
We-
pipe and the gutters. And
We maintain the infrastructure, yes, sir.
So suppose this pipe that fills your opponent's ponds got filled with sediment through natural circumstance. The pond all of a sudden dries up, so he's happy. But as a consequence, now all the water is running down the street because your catch basin isn't catching it, and it's flooding some other guy's house at the bottom of the street. What is the city's obligation in that hypothetical? And maybe this doesn't matter, maybe it does. I don't know. But I'm trying to understand the relationship here.
I think that the relationship is that the city's obligations is to make sure that the streets remain open and passable. In practicing for the panel today, one of the questions from one of our tort lawyers is, okay, well, what if there's a pothole and somebody, gets injured? If it's a relationship and it directly affects the city's maintenance obligations, then I think that we would be responsible for that.
But there's no obligation to ensure that the runoff doesn't cause harm in other places? I mean, suppose you just said, we're tired of this litigation, we'll just plug up the hole and the water will just go wherever it goes. Is that an option for the city, or and now it harms somebody else? How's that work out?
I think that there could be a direct causation that comes from the city's efforts to affirmatively block or plug up the pipe and the resulting water that would come off of that.
So basically, I mean, there is some case law, including an opinion from this court, which I authored regarding Walton County flooding properties. Mm-hmm. And there's, I believe it's the 1985 Gus Mikado Buick decision that talks about the common law regarding shunting water onto other property. You received a plat. You're not obligated, the city's not obligated to accept it. It accepts the plats and says, for a variety of public policy reasons, we want to accept this plat. We want this subdivision developed. We want, people to earn a living building houses, and we want people to live in our city. They accept the plat. They know there's stormwater on those streets based on elevation. I mean, that's how you determine stormwater. You look at the 100-year floodplain. You look at, varying degrees of that. And at that time you accepted the plat, another party said, we'll handle the stormwater, right?
Correct.
That entity's gone, correct? The
The-
developer no longer exists. The association received, I thought I saw where the association claimed an exemption from stormwater fees, but maybe I misread that.
No, they did. The city has a stormwater fee program.
Right.
And the association applied for and received a fee credit because they asserted that they were maintaining the stormwater system,
Which is false.
which turned out to be false, yes, sir.
Right. So the association says, oh, we're taking care of the stormwater. That's false. It's all going on to the appellant's property or some portion thereof. And it's water coming off of, I'll say, your streets. Either you own them or you've agreed to maintain them. How is that not inverse condemnation?
The reason it's not an inverse condemnation, Your Honor, is because of the fact that the stormwater permitting process is established so that the developer has to designate an entity responsible for maintaining the water. There is a live body that is available to maintain the system, and that's the property owner. Because the developer, when they applied for their permit or the exemption for the permit,
But you charge a fee. You actually charge the residents of that subdivision. If you're like other local governments, I assume, the city of Jacksonville actually says, you're going to pay a fee because we're in charge of maintaining the stormwater.
we're in charge of maintaining the stormwater that we have accepted.
But didn't you accept it by accepting the plat?
We did
The water
not.
on those streets?
No, I would say that we didn't because of the fact that the ponds weren't even on the plat.
But the
we
stormwater
accept-
was there. I mean, whether it goes to a pond or whether it goes to somebody's backyard is irrelevant, right?
Well, it's relevant from the standpoint of the developer designed the system.
Right.
And the city basically stepped into the shoes of the maintenance requirements for streets, curbs, and gutters, the things that we accepted in our acceptance letter. We never accepted the
Right.
overall maintenance of the ponds themselves. Now, I think it's a misnomer to say that it's city water, because we assume maintenance obligations over the streets, that somehow converts it into our property or our water. It would be like if you enter into a service contract to have your vehicle serviced, the maintenance guy doesn't all of a sudden own whatever part of your car that they're maintaining. We're there to perform the public service of making sure that the streets stay open. We're there to make sure that the stormwater system functions to the point of not interfering with the streets staying open.
Right.
And so, to say that because a
So
drop of
who is
water,
responsible for the stormwater?
I believe the subdivision is, because it's
But
the subdivision's water.
the association is not responsible, correct?
That's an issue to be decided by the state of Florida. I don't think that it's before this court or before the city to decide that, because who's responsible for maintaining the system is a permitting requirement, because that is where,
Well, the okay, I see your point. It's not your dispute you're arguing.
correct. And that's kind of really where the appellant wants this case to go, is to have this court create law that says by virtue of accepting a plat, that means that you're 100% responsible for every component that acceptance touches. And if that argument is furthered or is immortalized in a court decision, that's going to open up huge amounts of litigation from a policy
To keep the
standpoint.
metaphor going, the floodgates.
The floodgate. I avoided that, Your Honor. I just writing it out. I'm like, I'm not going to say it. It's going to open the floodgates because of the thousands of plats that local governments accept. Not only residential subdivisions, commercial subdivisions, industrial subdivisions, basically anywhere that has city streets that is subject to stormwater requirements, then whoever is the permittee that's designated to maintain those systems is just going to throw their hands up and say, you know what? Simon versus City of Jacksonville and Deer Meadows, we don't have to maintain these because the court determined that because the city accepted the plat, it also accepted all other components of the system.
But you agree that you have to maintain the stormwater to keep it off the streets, regarding Judge Windsor's question. You can't just plug up the catch basin. I mean, you could, and shunt the water away from the pond onto somebody else's property. They certainly have a claim against the city. Would you concede that?
I would concede that, but here's the critical thing about all of this is the city doesn't need the pond to meet its requirements under the plat. All we have to do is get water off the street. We could put a pipe that connects the end of our pipe that exists now out to a receiving water, and that'd be it. The purpose of the pond is to provide treatment for the stormwater system. And that under state law, that state rules, or that's the whole reason why you have to detain stormwater, is so that pollutants don't get automatically discharged into a receiving body. So the pond
Which means
itself,
you couldn't do what you're talking about. I mean, you're saying you could do that as a practical matter. You couldn't as a legal matter. If you said we're gonna fix this glitch, for lack of a better term, by putting the pipe out, the state would say no, you're not.
it's not a reasonable option.
Okay.
But what I'm saying
Well, you would
is,
just have to get a permit.
you'd have, if the state would permit
And
it,
the
we could
state
do
might
it.
deny it, but you would be responsible for the permit. And the argument here is that we accepted the streets, we shunt the runoff off the streets, we shunt it onto the appellant's property. Not our concern, not our problem. The association falsely claims, oh, we're taking care of the runoff. So I guess your argument is the appellant's cause of action is against the association.
Or the individual homeowners. The association, you'll hear from them.
It can't be against the individual homeowners. The stormwater's coming off the streets you maintain.
But where did the stormwater come from? Because if you go and you look at a cost benefit analysis, the purpose of this whole stormwater system, of which the streets are a part, The purpose of this whole stormwater system is to take stormwater that used to soak into the ground, that now has rooftops, driveways, sidewalks, all of that good stuff, now drains into the street. And the developer designed it so that the streets then drain into catch basins, and the catch basins drain into pipe that ultimately ends up in a pond.
All right, well, you indicated you want to share your time?
I did, thank you, Your Honor.
Thank you.
Thank you, Judge Thomas. I was getting a little worried there. Michael Orr, on behalf of the appellee, Deer Meadows Homeowners Association, who asked that this court affirm the trial court's ruling that the issue is moot. I want to correct one thing that opposing counsel said about the order that came out after the reply brief states to this court that the court had not determined who the prevailing party was as of yet. The appellant just told the court that the court has made that determination that my client was the prevailing party, but did so based on the fact that the court determined the counterclaim was moot. That's not what the trial court said. The trial court has now said that we are the prevailing party on the significant issue. And as your honors might glean from the argument in the briefs, the significant issue in this case was whose responsibility is it to maintain this pond? That was count one of the complaint, a declaratory judgment action to determine whether the city, the association, or the Simons had that responsibility. In the counterclaim, all we did was lay out the exact same allegations that we had in our affirmative defense and that were already in count one, and then we did, the association, a counterclaim for declaratory relief, and essentially said in paragraph 36 of that counterclaim that as a result of the Simons coming forward and bringing this claim and saying that we had responsibility, the association, we have now are necessitated to file this counterclaim to say that they should have to return it back to its original condition. That's something that hasn't really been discussed, but we're talking about a pond that's in their backyard behind a closed-in fence that they themselves enlarged and filled in. It was a dry detention area when it was originally platted, and this whole discussion was going on with the city. But for purposes of this appeal, your honors, the issue was moot. David Marcus, our corporate representative, said as such in his deposition that the only reason we were filing this counterclaim, our concern was in fact that we would be on the hook for maintaining something that we have no responsibility to maintain that had been altered. We said it again at our opening, we said it again at our closing, at the directed verdict or involuntary dismissal stage, and for those reasons this court should affirm.
Thank you, counsel. Rebuttal? I really didn't give you a chance to briefly conclude for the city of Jacksonville. Would you like to add anything else? I'm sorry, counsel.
No problem. Thank you, Your Honor.
You're welcome.
Very briefly, Your Honor. The trial court found that inverse condemnation wasn't available because of the fact that they were the fourth purchaser and they weren't the owner of the property at the time of the taking. Additionally, the trial court didn't focus on the statute of limitations issue. The court brought up the 2013 case in Walton County. Well, actually, I take it back. There's another 2013 case by the Florida Supreme Court that talks about, and that is Carriage Hills Condominium Incorporated versus JBH Roofing and Constructors, 109 Southern 3rd, 329, where the court said that the statute of limitations in a case like this begins to run when, well, actually, I take it back. That one doesn't relate to this. It is the Judkins versus Walton County case that talks about that the statute of limitations begins to run when the situation stabilizes. And this particular situation that we're talking about stabilized even before they bought the property in 1993. Certainly after that, as Mr. Orr mentioned, they've made significant modifications to the pond. They've performed maintenance on the pond for a number of years. So they were aware that, and they testified at trial that they were aware that the storm water was running into the pond. So statute of limitations is an issue. The issue that the trial court weighed in on for inverse condemnation is an issue for the reasons stated in our brief. Thank you, Your Honor.
Thank you. And Madam Clerk, if you would, add another minute 30 to the appellant's time. Thank you.
Thank you, Your Honor. Let me address, first of all, the issue of the statute of limitations that was just raised by counsel. The Brevard County versus Pulaski case is very instrumental here. In that particular case, the 5th District Court of Appeal, on facts that we believe are somewhat similar to ours here, ruled that use of another person's property is presumed to be with their permission. That is the presumption that has to be overcome by the city by clear and unequivocal evidence. In that particular case, Brevard County constructed a mosquito impoundment on 27 acres of the Pulaski's predecessor in interest property, the prior owner. And it was alleged to be under a 10-year easement. The court determined it was really a license based on the wording of it, but regardless of that, the Pulaski's predecessor in interest allowed that mosquito impoundment to go on for 24 years. That's what it says in the facts, 24 years, without any interruption, without any complaints with the county, and then the Pulaski's bought the property. And then they allowed that impoundment, the flooding of 27 of their acres, they were in the 13 upland acres on that property, to go on for another 14 years. So it went on for 40 years. And the court said, notwithstanding that it's gone on for 40 years, it is presumed to be with permission. It's a revocable license. The Pulaski's revoked their license.
But didn't the government do something in the Pulaski decision during this period of time that really is, as far as I know, the city didn't do anything with regard to the pond on the Simons property during any of this time, which my understanding of the Pulaski is that the government actually had a lot of active involvement with this.
That's absolutely true, Your Honor. They did have a lot of involvement.
Doesn't that make a difference?
They constructed this impoundment. You know, mosquitoes in a salt marsh, they have to land their eggs in the mud. Once you flood it, then they can't hatch. That's why they were flooding it. And they built levees and they did other things in that, something the city of Jacksonville has not done at all. They actually improved the property. That was argued as the basis of an irrevocable license by Brevard County, and yet the 5th District said, no, that's not enough. It's still a revocable license, and it's a taking. You have taken their land because you're continuing to use it after they have withdrawn their permission to do so. So I think the facts in Pulaski are even stronger in the sense that they support my clients in this case as opposed to supporting the city. I want to go on to the acceptance of the plat issue that was raised by the city here. The city can condition the acceptance of a plat on anything they want to. They have the power. These things go through committees. They could have said, you better make sure there's an entity responsible for maintenance. They could have said, how are you going to store the water when
Their
it goes
argument
through?
is the developer was responsible. When the plat was turned over to the city, in fact, there was a stormwater permit, if I'm not mistaken.
Actually, the developer was not responsible, Your Honor. The exemption application was made by Classic American Homes, which was
Regardless, though, the city accepts a plat, an entity has either obtained a permit or obtained an exemption, and that's their argument. How do you respond to that?
My argument is you should verify that that's the case. And you can require in your ordinance accepting the plat when you know stormwater is going to run off of it, that be an entity that must permanently be in place. Incidentally, the Florida Administrative Code at the time and now still requires that you can't even transfer that permit unless it's done in writing approved by the department and approved by the transferee. What the city is suggesting is that an individual homeowner should control stormwater as a matter of public policy to comply with the Federal Clean Water Act and put that burden on a homeowner who did not sign off and agree to be the maintenance entity when the city of Jacksonville has a storm water utility and can charge the residents and can charge the
All right, I'm
public
going
for
to
that
ask you to
control.
briefly conclude.
Thank you, Your Honors. We would ask that you reverse the previously requested.
Thank you. Thank you both. The court will be in a short recess.
All rise.